We're calling on the government to introduce and immediately pass the Stand on Guard law.
So a man in Lindsay, Ontario was awoken at 3:20 in the morning by an armed home invader, and the home invader ended up in hospital with life-threatening injuries as a result of the victim of the home invasion defending himself. And then, of course, was arrested by the police because, well, I guess just Canada. Let's hear what Pierre Poilievre has to say about this.
Conservatives are standing here today based on the principle that your home is your castle. We're calling on the government to introduce and immediately pass the Stand on Guard law, failing which one of our party's MPs will put forward such a bill. It will amend Section 34.2 of the Criminal Code, which right now says that you can defend yourself based on 9 very complicated and vague conditions. Now, look, if you're defending your house, you don't have time to think through 9 different conditions. You have one condition: to protect yourself and your kids. And it is wrong for the law, for the police, and for judges to apply a complicated, indecipherable legal doctrine against you when you were only doing what is right. Our amendment instead will change Section 34.2 of the Criminal Code to say that the use of force, including lethal force, is presumed reasonable against an individual who unlawfully enters a house and poses a threat to the safety of anyone inside. The proposed amendment is reasonable and prudent. It applies only to the unlawful entry of a home and preserves proportionality. Simply put, it means you have the right to use force to defend your home and your family against someone who threatens you and who has entered illegally.
The standard is reasonable force. But how can anybody be expected to be reasonable in an unreasonable situation? You've been woken up in the middle of the night. You're groggy. All of a sudden you've got adrenaline coursing through your system. You're confused. It's almost like a temporary insanity defense, isn't it? Like, how could you be expected to parse out the criminal code in that moment? It's obviously ridiculous. How can you be expected to be able to function rationally in that moment? I mean, it is literally in your mind. You have no idea. Is this life and death? The idea that anything isn't reasonable in that circumstance is absurd. No, whatever happens, happens, right? You do something unreasonable and put somebody in an unreasonable position where they can't be expected to act even rationally, in terror, in fear, adrenaline, they're confused. Once you cross that threshold, that's it. Your rights, you left your rights at the door or the window that you climbed in through. Done. Castle law. Over. So in determining whether the act committed is reasonable in the circumstances, the court shall consider the relevant circumstances of the person, the other parties, and the act, including but not limited to the following factors. Now, I hope everybody in Canada is memorizing all of this right now, just in case somebody breaks into your place. You don't want to get arrested. Let's see. The court shall consider relevant circumstances of the person, the nature of the force or threat. You have no idea. Somebody can look like they're not armed. They can have a knife in their pocket. They can have a gun. You don't know. It's dark. You can't see. You have no idea. B, the extent to which the use of force was imminent and whether there was other means available to respond to the potential use of force. Well, you know what? Now it occurs to me, perhaps everybody should have a counselor or a social worker. Yeah, that's it. Everybody should just have a social worker in their place at all times, right? Just in case somebody breaks in case you need other means to respond. I mean, what is this? The extent to which the use of force was imminent. You have no idea what's in this person's mind. You can't be a mind reader. The law should not require people to be mind readers. The person's role in the incident. Well, you're in somebody's house. I think we know your role. Whether any party to the incident used or threatened to use a weapon. Somebody could say, I'm not armed, and actually be armed. That shouldn't be your problem as the homeowner. The size, age, gender, and physical capabilities of the parties to the incident. Well, you know what? I tell you what, I'll give them this. If a baby breaks into your house, maybe if a baby breaks into your house, okay, maybe hold back a second. The nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force and the nature of that force or threat. I don't know. You wake up at 3:20 in the morning, there's somebody in your place. It just feels like a game over thing for me. The nature and proportionality of the person's response to the use of threat or force should not be your problem. Whether the act committed was a response to a use or threat of force that the person knew was all. Look, in the middle of the night, you can't think straight. You've got hormones flooding your system. You've got adrenaline flooding your system. You can't be expected to be rational or to, remember. Let's see, what did part F say? Or, what did part E say? Size, age, gender. Well, it's not a baby that broke in, so I guess I should be fine. Yeah, this needs to be changed because this is just perfect for an activist judge, just to go through all this. If you're an activist judge, you can find a reason to convict somebody or to put somebody through the hell of a trial because you used too much force. It was not proportionate force, right? I say you have no idea what's in that person's mind. You don't have any idea whether that person was armed or not. Even if they look like they're not armed, you have no idea if they are. You won't know until the threat is neutralized. It's all pretty simple to me. I think we need new laws in Canada. Sane laws. Sane laws. And let's hear this as well. Here's just one more, Pierre Poilievre. Now, we haven't heard anything from Carney on this, have we? And he can't because it's self-defense isn't a progressive value, right? Protecting the criminal is the progressive value. So he can't. He's kind of, his hands are tied. He can't weigh into this.
You need to be able to do whatever you think is necessary to save your family. And so our caucus is going to be talking over the next several weeks about changes that the criminal code may need to clarify the absolute right of Canadians to defend themselves, including by taking very aggressive and even lethal action against someone who's broken into their house.
This is the kind of forthright comment that we need from conservative leader in Canada. We don't need watered down. We don't need, what will the CBC say? What will, purple-haired gremlins say? What will far-left activists say? What will far-left communist academics say? Just speak to sane people. Don't change it. Don't water it down. The people who don't like it will never vote for you in a million years anyway, right? Those people would rather be victimized than vote for you. So just this is it. This is what we want, right? Anything necessary. And in those circumstances, anything is anything because you have no idea what is in that other person's mind. And you shouldn't have to read their mind. And you shouldn't have to be a doctor and do an on-the-spot health assessment of that person if you've done too much harm or not. That's not your problem. The second that you invade a home and you cross the threshold, you leave your rights outside. Anyway, that's all I'm going to say about that. Please like, share, and subscribe. Subscribing really helps me out. I thank you for that. I will see you next time.